and welcome to the Education for Justice Global Podcast Series. Today we will talk about some of the most topical and highly debated aspects of trafficking in persons. What happens when victims of trafficking are treated as offenders by the justice system? How is the principle of non-punishment applied in practice? What is the role of technology in trafficking in persons? What about the double victimization of technology and emerging trends in this field as tools to victimize in the context of trafficking in persons? I am Zoe Sakeliadou of the Education for Justice Initiative of the United Nations Office on Drugs and Crime. I am honored to introduce today's panelist, Professor Felicity Gary of Deakin University from Melbourne, Australia, academic, prominent international attorney, and prolific author. Felicity, you're not only an academic professor, but an active and prominent international attorney that has taken up many complex cases on trafficking in persons. Your experience spans from defending victims of trafficking facing the death row to terrorism cases. Can you tell us, in your experience, what challenges continue to hinder effective access to justice and remedies for victims? How is the principle of non-punishment applied in practice? And why is it that victims of trafficking can be treated as offenders by criminal justice systems?
Well, I can try. It's a huge topic, and I'll try and answer that in a simple way. The result of my work, both as an academic and as a barrister, is that I get to see that the two sides of the coin, if you like, victims who are also perpetrators, so trafficked persons who also commit crime, and investigations that look at those people as suspects instead of seeing them as victims or seeing them as trafficked persons. So in many ways, the work that I do is almost to try and defend those groups of people that have ended up in prison where their trafficking status has not been recognised. And that means defending them individually if I do cases, or defending them as a cohort or a group if I'm engaging in academic research or submissions to government to try and change criminal justice processes. So that requires us to look at, in a way, three things. One is looking at criminal suspects as victims of human trafficking, and then accepting the principle of non-punishment, non-prosecution, what I would agree is really non-liability. So what we're thinking about here is then that those persons are not liable for that crime because they've committed those acts as a result of the means and the purposes of others. So in the common law, you might say that they're not voluntary, that the actions have been done because of the means and the purposes of others, but not in that limited common law way that volition is defined as, but in a way that recognises the multiple complex factors that there are in relation to human trafficking. The second area is the manner in which we investigate things. So the use of technology that traffickers use to control trafficked persons, and that investigators use to investigate those trafficked persons as criminals or even as victims, so that there's a victimisation in the way in which technology is used. And thirdly, there's a real overlap that's often missed, which is not just this victim-perpetrator paradigm, the victim who commits a crime or the victim who stays in an organised criminal network, but the overlap between organised crime in the sense of using people in exploitative ways and corporate responsibility for business and human rights. Overlap between organised crime and corporate responsibility for exploitation. Now, I'm not going to talk much about the corporate aspects, but unless we investigate slavery and slavery-like practices in supply chains, whether those are criminal or corporate supply chains, with that idea that trafficked persons are not really criminals at all, then we're never going to reach that ideal of protection that is set out in the trafficking protocol.
I see, and you're raising very important and highly debated issues. Supply chains is at the forefront now of international interest. Corporate liability is another issue that I think deserves a little bit more research in that respect. You've mentioned technology, Felicity, and I want to go back to that. In your experience, from what I understand, technology creates, let's say, a double victimization for victims. If you could perhaps elaborate a little bit on that, and I will ask you also to tell us how you see the COVID-19 pandemic impacting the use of technology in the context of trafficking in persons.
Yeah, I mean, it still fits in this idea of this double victimisation, I think, is victimisation by traffickers and victimisation by states that do not have processes that allow for non-liability. So I often write about it, particularly in relation to women, that we need to contribute to the visibility of women in justice systems, not just as victims and vulnerable and worthy of protection, but as witnesses to the global problem of human trafficking. So this idea that we approach people as witnesses to the problem that allows us to direct our attention to the traffickers further up the chain means that we have to accept non-liability. Now, yes, that's really controversial, truly controversial, that we move from a world that's tough on crime and prosecuting people and all the rhetoric and languages about criminality to a world that accepts that those persons who act as trafficked persons are not criminals at all. So it's hugely controversial and a very difficult area defending and doing academic research. And then if you add into that, essentially what I'm saying is, look, criminal justice systems are not effective. Domestic implementation of international commitments is woeful. Add to that also, you're not using technology correctly, in the sense that this eternal drive to use technology to control people or to assess people or to make decisions about people, again, removes particularly women's autonomous choices. So examples in cases that I've known about are traffickers control women in sex trafficking using an iPad or a phone. All the appointments come, there's spyware, location tracking, so that those women really can't move or get out of the control of the trafficker because of the way technology is used to control them. Then if you have an investigation by a police force, first of all, you might have a problem with the police understanding that that person is a trafficked person. So if it's in a sex work context, it might be somebody who is involved in the organisation of the premises and the women working in the premises. Those persons are seen as controllers, but they're often trafficked persons who've just managed to gain a slightly different role or a level of responsibility. It doesn't mean they're not trafficked. And so first of all, you've got the problem of the investigators even understanding the complexities of human trafficking and exploitation and slavery and slavery-like practices and all those definitions in the UN trafficking protocol around abuse of vulnerability and deception. So you've got all those problems of lack of awareness, lack of education, police misunderstanding. You've got traffickers who've controlled that person remotely, harder to get at, unless you treat that person as a witness to this global problem, as not liable for that offending. You're not going to get to the traffickers because they're remote. The technology contains all that information, or some of that information, and let's say it's seized by the police. What they then also have is everything personal about that victim, that trafficked person. And so on police records, that person is recorded as a victim or a suspect. So there start to be state records of that person's status. And if they're wrongly prosecuted, let's say it's in the context of drug trafficking, that they're found in circumstances in growing drugs in a house or trafficking drugs abroad in a bag where they've been deceived into carrying that bag, or they're not deceived, but they're in a situation of abuse and vulnerability. Mm-hmm. Even if you get in your police records, you've then got that person recorded as a suspect, potentially found to be a trafficked person, but what's the process for removing that investigation from state records so that that person is, their private information is not known by the state? You might take away that person's telephone for the purposes of investigation that contains their whole life, access to all of their social media, all of their the applications on their phone. Most of us don't use phones that have particular encryption. So although that same device might have been used for the purposes of control, and the police can say, oh yes, spyware, location tracking, okay, we'll accept you're a trafficked person, they also have all that personal information about that individual. And it really, really troubles me, the levels of surveillance and intrusion and data and privacy issues that relate to trafficked persons, and that are really, again, widely misunderstood, that somehow technology is going to be the solution to combating human trafficking, when the dangers are this double victimization of the very persons that we're supposed to be protecting.
I see your point, Felicity, and may I ask a question in terms of what are you considering as a way forward or as a solution? Would you see, for example, the introduction of a specific defense in criminal codes? What is the best way, to ensure that victims are not doubly, let's say, victimized?
Yeah, I think first of all, I'd go into prisons, audit prisons, find the trafficked persons in prisons and get them out. And then, so that one's always forgotten. Everybody says, oh, let's have a defence. But what about those people who are already wrongly convicted of crime that are sitting in prison? So that's number one. Number two is, yes, I think what we can show is, since the UN trafficking protocol was signed up to by so many states and territories, we haven't really had an impact on trafficking in crime. And if that impact is not occurring, then we've got to look at why. So you can look at the four jurisdictions I have done the most research on are obviously England and Wales, and Australia, Indonesia and the Philippines. Now that's largely because I've done cases in that area. So back in 2006 in England and Wales, I did a case involving a young woman who was accused of being a human trafficker at a time when it really was widely misunderstood that someone could climb the chain of command in order to survive, which is now better understood. There's a little bit of research around the victim perpetrator paradigm, but it certainly wasn't understood when we dealt with her case, and we weren't successful in defending her, and there weren't really frameworks to defend her at the time. I've dealt with international conspiracies to move people in situations of employment servitude in the rag trade, and they were dealt with as conspiracies. Was he a conspirator or not? Not thinking through, is that person a victim of servitude? Is that person being moved in a situation of debt bondage? And again, at that time, it wasn't understood. And various other cases that raised these issues before there were really any frameworks in place. And the research led me to consider the law in Indonesia, and I helped out on the case of Mary Jane Veloso, who was a trafficked person who trafficked drugs from the Philippines to Indonesia. And she raised her status as a trafficked person, all of which was ignored in the trial, convicted of drug trafficking and given the death penalty. And when I came along, it was very short period of time, about a month before she was due to be executed on the same death row as Australians Chan and Sukumaran. And I helped the Philippines lawyers who used the human trafficking referral mechanisms in the Philippines to identify her traffickers. And to cut a long story short, there was a massive campaign and a huge petition, and the then two presidents of Indonesia and the Philippines spoke, and she was given a last minute, albeit temporary, reprieve about 30 minutes before she was due to be shot. So suddenly there was this understanding, certainly by the people of the Philippines, goodness, that could be me, trafficked abroad to be a maid, deceived about what's in the suitcase, carrying drugs and ending up on death row. And it seemed to me this was all of my research in one place, and I was pleased to be able to help those amazing lawyers in the Philippines to assist her. And her case is still ongoing. The recruiters have now been convicted of trafficking other people. The issue is, how does she give evidence, because she's still in prison in Indonesia. That question has been dealt with by the Philippines Supreme Court, that it's akin to a dying declaration because she's on death row. So you've got all these processes that are trying to work out, how do you protect Mary Jane Veloso, but also how do you have criminal justice processes that recognise her status. Now, in the Philippines and Indonesia, there are some protective laws about not prosecuting and not punishing victims of trafficking who commit crime, but nobody raised in her criminal proceedings. In England and Wales, there is now a Modern Slavery Act, so there's a defence for human trafficking victims who commit crime, but only in relation to certain offences. So it doesn't protect trafficked persons, it just protects certain trafficked persons who are not involved in certain crimes. So you can start to see the crime rhetoric coming back in. And then in relation to Australia, where I also work, and I'm speaking to you now, there's no defence at all. You'd have to try and run duress or argue some form of abusive process on the basis that justice was not being seen to be done, which I imagine wouldn't go down particularly well in Australian courts that have no real history of dealing with human trafficking. And in a situation where there are laws to prosecute traffickers, which are very rarely used, and significant policy on the protection of trafficked persons. Australia is getting a lot better at its policy, but no law. So there you have England and Wales trumpeting how marvellous their Modern Slavery Act is, but Indonesia and the Philippines have had similar laws for a very long time that are not implemented, and Australia has no defensive law at all. So we can see how different jurisdictions have implemented the ideas of protection that are in the UN Trafficking Protocol as law or policy, and all of which are ineffective because we're still locking up very vulnerable people, and human trafficking is not necessarily raised in their criminal trial, and technology is still used in order to investigate and retained, despite that person being a victim. That person's still recorded as a criminal. And the law in England and Wales is better. There is a system for those who want to appeal out of time, who've been wrongly convicted, and there is a system for those to have a Defence Act trial, but it's quite restricted. It's not this full sense of non-liability. When the Court of Appeal was asked to widen the framework of duress, it didn't happen. You know, let's have a legal foundation, but instead there's a policy decision as to whether or not someone can get their conviction quashed. So you're really asking most jurisdictions in the world to change the way that criminal justice is done, by recognising that what that meaning of protection really is. It means don't prosecute people who are acting as a result of the means or purposes of others. And that's a very long road to travel to get jurisdictions and politicians in particular to understand what's necessary. And I think those cases that I've outlined today give you the reason why it's really important. And if you look at the figures for vulnerable people in prison, a portion of those are going to be people who were compelled to commit all types of crime that just simply shouldn't be there.
Felicity, thank you very much. I think all the issues you raised are the issues that epitomize, in a sense, the complexity of trafficking in persons. It's not always, straightforward cases. And by referring also to specific examples of cases that you've worked on, you bring back to the forefront the fact that we speak about, human beings, people that are kept behind bars, people that are on the death row, and all this in the context of having to commit, criminal offenses as a consequence of being trafficked.
It fascinates me every day. I've got a case going on at the moment where there's huge publicity, a police force, I won't say where it is, but a police force having huge publicity. Look, we've protected this woman from traffickers, we're not prosecuting her, we recognise that she's a trafficked victim. And yet the same group of traffickers have trafficked other women who are currently in prison or deported. And so it's recognised in relation to one, but in those other cases, it wasn't understood. And that wasn't dealt with in their trials. And then if you're trying to bring a case on, how do you get it to court where there's no mechanism? What do you do? What do you say to a court? In England and Wales, you have to say, well, she wouldn't have been prosecuted if we'd known her traffic status. But you really need a legal framework to say, right, that's a miscarriage of justice. Let's quash that conviction. That's framework by which you can reach a not guilty verdict if people don't believe you and you are in fact telling the truth. And here's a system whereby we can empty databases of private information and make sure that it's recorded that you're a victim of crime and not a suspect or a criminal.
We, Felicity at Education for Justice, are very happy to have you on board, and we are eager, let's say, to give space to your voice and bring to the forefront the complexities of the issues that you are raising. I'm afraid our short podcast has come to an end. This is the first but not the last in our series. So I look forward to hearing from you again. Thank you very much.
Thank you very much for having me. I was grateful to have the opportunity to sound off about something I could see as so important. Thank you.
Thank you for sharing with us your thoughts and your experience. Let's inspire change together, and let's work together to achieve the Sustainable Development Goals. Higher education matters, and the United Nations Office on Drugs and Crime is proudly partnering with hundreds of universities from around the world to advocate for the Sustainable Development Goals. The Education for Justice initiative is part of the global program for the implementation of the Doha Declaration, funded by the State of Qatar. Tune in for the next episode of this Education for Justice Global Podcast Series that will be published soon on our Education for Justice platform. In order not to miss any of our next podcasts or opportunities for higher education institutions, please register yourself at our Education for Justice platform. Let's inspire change together.